The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 841, and it is coming to you on Monday the 17th of October 2016. On this program, I will speak to you on the topic Court-Appointed Mediation. But before getting into the topic, a few preliminary comments. Firstly, let me send out my deepest condolences to all families which have suffered recent bereavements, and in particular the family of Mr. Sutton of Georgetown, whom, according to the newspaper reports, was gunned down in broad daylight. I can imagine how that family felt when they heard the tragic news. My condolences to all who have suffered losses, whether by natural causes or by violence. Secondly, let me say happy anniversary to former Superintendent of Police, Mr. Grenville Dick of Riley, and his wife, Mrs. Thelma Dick, who celebrated today, or are celebrating, because by now they should be still celebrating, 29 years of marriage. My brother Grenville, congratulations. You know, he has always been one of my favorite policemen, and we have had a very good friendship over the years. And I see him every now and then now that he has retired. I wish both of you God's richest blessings, and I hope both of you live to see many more years of married togetherness. And let me say finally, for these preliminary remarks, congratulations to one Miss Mandela Rosalie Campbell, a person of my acquaintance, who on Friday the 14th of October celebrated exactly 5 years of her admission to the Bar of St. Vincent and the Grenadines. Congratulations, Mandela, and may you have many more years of practicing in the law. And thank you for being there with me in my chambers, giving me all the assistance I need, you and Mr. Macaulay Peters. Now, court-appointed mediation. Over the past few years, persons involved in the law have been trying to devise various means of having disputes settled other than by trial in the law courts. So the phrase alternative dispute resolution, or ADR for short, has been one that has become current in the legal jargon. ADR. For many, many, many years, we have known of arbitration as the main form of alternative dispute resolution, particularly when it comes to commercial disputes. But in recent years, here in the Eastern Caribbean Supreme Court system, we have become acquainted with a new procedure called mediation. And in this program, I will explain to you what mediation involves. And I will give you some of the main characteristics of the mediation process. Briefly, mediation is a procedure by which parties who have a legal dispute agree to have the matter settled with the assistance of a mediator. In St. Vincent and the Grenadines, we have many persons, I think the list is approaching 30, who have been trained here in the Eastern Caribbean as mediators. They take a course, and then once they have satisfactorily completed the course, they are given the title of court-appointed mediator. There is a list of them. Some lawyers, in fact, in St. Vincent and the Grenadines, there are more non-lawyer mediators than there are lawyers, so you don't have to be a lawyer to be a court-appointed mediator. So at a certain stage of a legal dispute, when it is making its way through the court, the judge might invite the parties, or the parties' lawyers themselves might suggest to the judge that they should attempt mediation. That is, they should attempt to settle the matter guided by a court-appointed mediator. The first characteristic of court-appointed mediation is that it is voluntary, and both parties to the dispute have to agree to attempt mediation. So the two parties, and of course there are cases where there are more than two parties, but they get complicated, so I will stick to the case where you have a claimant on one side and a defendant on the other side. So two parties have a dispute. It has already been filed in the court. Each side has his or her lawyer. Either the parties or one of them can suggest to the other, let us try mediation, or the judge might invite the parties to consider mediation. That means an attempt at settling the matter out of court. Now, mediation has several advantages. For one thing, it is far, far cheaper than a trial in court, in that if both parties agree to submit their dispute to mediation, each party has to pay only $400 into the court for the privilege of having a court-appointed mediator attempt to settle the dispute with them. So let us say that the idea of mediation comes up, regardless of who raises the question, and both sides says to the judge, yes, we wish to try mediation. The judge will make a mediation order. The lawyers would be asked to pick one of the mediators who is on the court list. The lawyers get together, sometimes right then and there at the bar table, and they decide on a name. Having picked the name of the main mediator, the judge will ask them to select an alternative name. So they would look at the list again and they would come up with a second name, so that in case the first person who is chosen as mediator is not available, or anything happens that causes that person not to be able to conduct the mediation, they will then use the alternative person to mediate the dispute. And the judge will make the order naming the mediator and the alternative mediator, the alternate mediator. And the judge will direct that the mediation should take place within 45 days after the date of the mediation order. So both lawyers and their clients leave the court, and in the 1 or 2 or 3 days they receive an order from the High Court setting out the mediation referral. Each side is encouraged to get together to get a bundle of documents to give to the mediator. Now, the documents are not given to the alternate mediator. You just deal with the mediator, who is the first person chosen. So there is an agreed bundle of documents. That is, the lawyers go through the case and they decide, okay, these are the main documents in the case. Let us have an agreed bundle and put it before the mediator. In cases where they may not be able to have an agreed bundle, each side gives his or her bundle of documents. So you have 2 sets of documents, but it's usually preferable for the mediator to have just 1 set of documents. So that the mediator has time to study the documents, to see what the case is all about, to see what are the rival contentions by the both sides of the dispute, and the mediator acquaints himself or herself with the facts in issue. Mediation usually takes place in one of the offices in the court building. And as everybody knows, upstairs the Courier's building, upstairs the Courier's City Store, the 2nd floor at least, or the middle floor, is used as the High Court, and above that there are some offices. Usually one of them is used as the mediation venue, or sometimes it's in one of the offices at the High Court itself. On the appointed day, the parties show up with their lawyers, although they don't have to have their lawyers present, but parties usually like the comfort of having their lawyers with them. And they go before the mediator, and the mediator gives them the ground rules. Among other things, the mediator will tell them that he or she is there to help them to settle the matter among themselves. The mediator doesn't impose a settlement on the parties. The mediator doesn't say, look, I have decided that this is going to be the position and you all better agree to that. No, no, no. The mediator's role is to encourage the parties to come to a settlement. So there are several techniques which mediators commonly use. And this is one of the most frequent techniques. The mediator will sit there at the head of the table, the lawyer and his client on one side, the lawyer and his client on the other side. Now, witnesses are not involved in mediation. They are for the trial if the matter is not settled. So there are no witnesses there. It's the parties and their lawyers. They sit at the table and the mediator will explain that he will say, I will attempt to encourage you to settle this matter. I would wish to hear what you all have to say to me. And then I will ask one side to leave the room, and I will hear what the other side has to tell me privately. When that side has told me privately what their position is, I will ask them to leave the room, and then I will call in the other side and hear what they have to tell me privately. So the mediator is told by both parties what their position is, and they will tell him that in private. and then they will get back together, everybody, and a general discussion would take place. It's not formal as in court where you have to, one stand at a time. It's a conversation. But the mediator will stress that the mediation process is really for the parties, not so much for the lawyers. That is not, lawyers don't get there to argue legal points. They're there to assist their client, to clarify matters, but the mediator really wants to hear the parties themselves who are in dispute. And depending on the nature of the matter, the mediator might suggest lines along which they might wish to proceed. He may suggest one course of action, one side may say no, the mediator will then suggest another course. What the mediator will be trying to do, and this is what the training of the mediator would have prepared him and equipped him to do, is to see if he can't get the parties to see eye to eye on the basic elements of the dispute. Because many disputes have one basic central issue and a lot of other peripheral issues not really germane to the central issue. So the mediator will try and get the parties to see what is the real problem between them. Because there might be other side issues which are not, as we would say, no big thing. So a discussion will take place, there'll be back and forth. The lawyers are encouraged to say as little as possible. They're supposed to sit back and let their clients do the talking. Some clients would prefer the lawyers to lead. Well, that is up to the client. But the mediator would generally want to hear the two parties. Eventually, after that discussion, either the parties may decide, okay, we'll settle, and the terms of the settlement would be agreed between them, which means that the mediation would have been a success. Or the parties may say, no, we simply can't agree, we can't settle. There's too much of a gulf between the respective positions which we hold. We can't see eye to eye, so we don't think the mediation is going to produce a resolution of this dispute. If the mediation is successful, the mediator writes out the agreement arrived at by the two parties. He reads it over to them to make sure that is what they have agreed. He gets them and their lawyers to sign it, and then he makes a report in the next day or two back to the judge to give the judge the result of the mediation. If, however, the mediation is not successful, if the parties cannot agree, and the mediator tries everything he can to persuade them to agree and they simply will not agree, then the mediator will say, well, I have to report to the judge that there has been no agreement, the mediation effort has failed, and let the judge take it from there. But the important thing is that when a matter goes to mediation and the mediation fails, neither of the parties can say in court what was discussed at the mediation. The mediation process is totally confidential, so that when the matter goes back to the judge with the report that mediation has failed, the judge will say, okay, let us put the matter down for trial. If there are any other directions the judge wants to give the parties, pre-trial directions, the judge will do that, and the date will be set for the hearing of the case. The judge doesn't want to know, and the parties should not say what happened at mediation. The judge doesn't want to know whose fault it was. The judge doesn't want to know how close they came to an agreement. It's either you have a mediation agreement or you don't. Although it is possible, if a matter has multiple issues, it is possible for the parties to agree on some issues and to disagree on some issues. If the issues on which they agree can be separated from the issues on which they are still deadlocked, then they can report to the judge that, okay, we have agreed on issue A, B, C, so those would no longer be part of the trial, and we'll just want to go to trial on the issues D, E, F. That is quite permissible. But what takes place in mediation cannot be revealed if the matter goes to trial on the failure of the mediation. Now, if the mediation is successful, the mediation agreement signed by the parties, as I told you before, is presented to the judge on a date after the mediation hearing. The judge will confirm with the parties that that is what they agreed, and that agreement is approved by the judge and it becomes an order of court. So, an agreement arrived at in mediation before a court-appointed mediator and approved by the judge has the same force as an order made by the judge if there were no mediation. So once that is entered as an order of court, it can be enforced as if the judge had had a trial and made the same order. So a mediation order is not something that you can say, oh, you change your mind, and oh, that is just before the mediator, man. I'm not. No, you have to follow and obey a mediation order just as you would any other order of court. And if you had taken one position in a mediation which turned out to have failed, you are free in the trial to take the opposite position because you are not bound by any concession you make during the mediation if it has failed. In other words, at the mediation session before the mediator, you may have been willing to give up one or two things. But if mediation doesn't succeed and the matter goes to trial, you don't have to, you're not bound by what you had been prepared to give up in the mediation because you start back from scratch if the mediation fails. But mediation has two big advantages. One, the cost factor I mentioned before. And secondly, and more importantly, the time factor. Because a mediation session would normally last a morning or an afternoon. You'll seldom get a mediation going through the whole day. Whereas many matters go before the court occupy 2 or more days of trial time. And mediation has the beauty of leaving both parties satisfied that what has resulted from an agreement between them. Nobody has won, nobody has lost. Whereas if you go to a trial, the judge has to rule for one side or the other. Of course, there are cases where the judge may rule for one side on some issues and rule against the same side on other issues. But at the very least, mediation, if successful, restores a semblance of harmony, particularly where there are relatives who are at war. And if the mediation results in an agreement, it usually has the effect of allowing those relatives previously warring to be knitted back together. So there's no lasting animosity, no hatred to continue down the line, pass on from generation to generation. So that if you have a matter in court and your lawyer suggests to you that you should try mediation, don't think your lawyer is trying to sell out the case as you may feel, or doesn't feel that your case has strength. No, the lawyer is trying to do what is best for you. Not that he feels you would not win the case, but there are things that the lawyer will take into consideration that may not occur to you. And one of the obligations we have as lawyers is to try and maintain social harmony. You see, we live in a society which is guided and bound by the rule of law. And the role of lawyers in the legal system is crucial. Crucial to the maintenance of civilized values and civilized standards. We are not supposed to encourage people to keep at war with one another. We're supposed to try our best to keep harmony between people, even when they themselves are trying to be at war. This is why in the legal profession, in the height of a case, you refer to your opponent as my learned friend. You are supposed to show respect to other lawyers. It doesn't mean you care less about your client's dispute. But we as lawyers are not supposed to enter into the hatreds of our clients. We're not there as bulldogs to be sicked on to the opponents of our clients. We are supposed to maintain our objectivity, maintain our balance, our levels of courtesy and civility. So sometimes people feel, well, they didn't think the lawyer fighting enough because he didn't get on and prance up and carry on and insult the other person when they're cross-examining. No, that is not our role. We're not there as bad dogs for you to sick on people because you pay fees. We're there to help maintain social stability. Yes, we will do our best to try and maintain justice for all, so that the next time your lawyer suggests to you that you try mediation, give it a try. Your lawyer knows what he or she is doing, and cooperate with the system. Amen? Okay. So that is all from this program of The Law and You, program number 841. I look forward to being of further service to you next week, Monday, DV, for another presentation in this public service nation-building series, The Law and You. Before I close, let me say welcome to my cousins, Sandra and Wilma, who have come to visit their mother, Tanti Emily Ballantyne in Layu. Hope you have a lovely holiday in St. Vincent and the Grenadines. And reminding one and all in the Baptist community that we're having a consecration service on Sunday where we'll be having 4 ministers elevated to the position of canons, and 1 will go on to be archdeacon. And we look forward to a lovely ceremony at St. Elizabeth Cathedral, 9 o'clock this Sunday morning. And next Sunday, the 30th, 2 o'clock, harvest at St. Elizabeth. May the good Lord continue to bless us all, and may He assist us in keeping peace and harmony in St. Vincent and the Grenadines.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC, and brought to you on SVG-TV as a public service.